Alright guys, I'm going to show you here in this video that driving is a regulated occupation for hire. Not because I'm saying so, but because the law says so. The fundamental law of our land, being constitutional law, which refers back to the Constitution. And we're also going to cover a little bit about what is constitutional law and what each one of these little segments like this right here are, and then you come to a number, what that is when you see that in constitutional law. Alright guys, I'm going to show you here in this video that driving is a regulated occupation for hire. Not because I'm saying so, but because the law says so. The fundamental law of our land, being constitutional law, which refers back to the Constitution. And we're also going to cover a little bit about what is constitutional law and what each one of these little segments like this right here are, and then you come to a number, what that is when you see that in constitutional law. That each one of these is a constitutional provision that has been decided by the courts. And the reason that all of this is so important is you're being lied to. And as it stands right now, we could lawfully arrest every single person holding office and lawfully put them all in jail because they have been lying and violating the Hobbs Act. They've been extorting all of us. They have lied about how the law has applied, which in itself is a felony. And this stuff has gone on for so long, it's time that we all get a better understanding. So let's get started, right? And one of the things that we talk about here is the state having the power to require the procurement of a license, right? And it says this power carries with it the power to prescribe reasonable conditions precedent to the issuance of such licenses and to classify drivers for special regulation, right? And that does all constitutes an exercise of the police powers to regulate the use of the highways in the interest of public safety and welfare. And you find that at 7 Amjur 2D automobiles, subsection 102, power to license constitutional limitations, right? But then when we come down to the next section, it tells you there, under the first provision of that piece of constitutional law, that a state can lawfully exercise its police power to protect the public health, safety, welfare, and morals by promulgating laws and regulations that reasonably regulate occupations. Yes, you see, the driver's license is an occupational license. And this is what many people do not know, right? And the police power, as in this case here from California, it cannot be extended beyond the necessities of a case and be made a cloak to destroy your constitutional right to travel or your private property, right? Now, here's what a lot of people don't know. Under the constitutional guarantee of liberty, one may, under normal conditions, move at his or her own inclination along the public highways or in public places, and with places, and while conducting himself or herself in an orderly and decent manner, neither interfering with nor disturbing another's rights, one will be protected not only in his or her person, but in his safe conduct, right? And it says, for example, the right of a citizen to drive on a public street with freedom from police interference unless he or she is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right. Right? But then it says, however, the liberty in each individual in a public vehicle or a public place is subject to reasonable limitations in relation to the rights of others. Well, what is a public vehicle? And why do they get the right to limit it? Right? So we come down, we look, and this was out of a court case where they defined a public vehicle as a vehicle seeking employment from the general public. And they used, in that case, they cited the Webster's New International Dictionary from 2005, the second edition, 1956, right? So now we know that a public vehicle is a for-hire vehicle. Well, what does the constitutional law say about for-hire vehicles, right? It says the use of the highways for the purpose of transporting persons or property for hire by the ordinary means is incidental to and consistent with the primary purpose of their establishment, and it is therefore a proper use. It says, in the absence of any restrictive regulation, such use is not, however, one which may be exercised as of a right, but is a special or permissive use. And I added in a privilege, because this is what the state tells us driver's license is. It's a special permissive use, a privilege. So, why are they telling us that it's a special permissive use? It's because the license grants you the ability to operate for hire. It doesn't grant you the right to travel about from your home to the grocery store, from your home to work. You already have that right. All right, that's all set in stone already. What you don't have is the right to operate for hire, to use your car as a taxi. Right? Now, mind you, all this constitutional law I'm giving you is from 2021. Right? And as I've said, the state claims driving as a special permissive use, a privilege. And up here they're telling you the privilege is to operate for hire. Well, now we come down here and we look at this, and it says motor vehicle registration is a traditional government function because the operation of a motor vehicle is a privilege. Again, we're back to that privilege. Well, that privilege is to operate for hire. And it says the legislature of each state may, in the exercise of the police power, enact reasonable regulations requiring the licensing or registration of motor vehicles, including, now remember, under the law, whenever something gets included, whatever's included, it excludes everything else. And I'll show that to you in the law here in just a little bit later. Right? So it says including private motor carriers of property and public or common carriers of persons or property for hire. Well, that's 7 Amjur 2D, automobile subsection 60, power of the state to license or tax generally. Right? Now, mind you, folks, when you're going to use this stuff in a court case, you have to turn in these pieces, all these pieces of constitutional law as an exhibit. But I already have all this stuff where you'll be able to download it and it is self-authenticating because it comes from Westlaw or LexisNexis or Casetext. Those three companies, they're this, whatever you get from them that you turn into the court as an exhibit is self-authenticating. You do not need to authenticate it. All right? And it says licensing or registration enactments frequently are made applicable to motor carriers. That is, to vehicles operated for compensation or for hire. This is why when you see some of these videos of people who tell the cop that they're not operating for compensation or for hire, he doesn't give them a ticket and he lets them go on their way. Because they used the right words. They only have jurisdiction for license and registration and all that if you are for compensation or for hire. Now, let me be very clear here. This don't mean that you can drive your car down the road in the dead of night with no taillights working, right? Because that falls into a safety issue, and safety issues apply to every car. However, contrary to what the police tell you, you do not have to have both taillights working. The law says only one must be working. When you read into your state law, you'll find a section of it that says you have to have at least one headlight working and one taillight. And as long as you've got that, they cannot ticket you for a taillight being out or a headlight being out, as long as one is working. Right? They can stop you in a courtesy and let you know it's not working. But contrary to what they've been doing, they cannot mandate you fix it. The only time they can mandate you fix it is if neither taillight or neither headlight is working. All right, and here we get into why this step applies to motor carriers, and it's because the use of the highways for the purpose of transporting persons or property for hire is a special or permissive use. And like I said, I will have links below the video that will take you to where you can download all of this constitutional law and things like this that I have written. Right? And you have stuff like here where it says, in addition to motor vehicle license or registration fee or tax based upon seating or load carrying capacity is not invalid when laid on motor carriers in interstate commerce. Do you see the recurring theme here? And remember, each one of these, when you come to a number from there to there, that is a constitutional provision. Now you might say, well, why is this important, right? Well, here's why. All right, let me get this up, if I can find it. They've already determined and said that, where is it at? Right here. This is a piece of constitutional law that I have up for people to download for 16 CJS subsection 8, right? And it says accordingly, constitutional provisions control in any conflict with lesser laws such as statutes, local ordinances, administrative regulations, and case law. So this stuff overrides even case law that the court wants to cite or that the prosecution wants to cite. Okay? And like I said, what you got to remember, right? You come through here, and here's one constitutional provision right here, right? And then right here, yeah, you see how it takes you to the case law down here for each section of where the footnotes are at, to tell you what each constitution, to show you the case for each constitutional provision. Those are all Supreme Court cases, folks. Right? But then you get down here, and you come to 2, that's your second constitutional provision. And your third and fourth constitutional provision right here that I've got highlighted. Your fifth constitutional provision. See, this is important, because these constitutional provisions, they control every case that you enter this into. Right? So that stuff's very important. And many of you have heard them talking about the Hendricks versus Maryland court case. And I'm going to show you why what I'm reading out of it is correct versus what many lawyers are trying to tell you about Hendricks versus Maryland. These lawyers are lying to you. They're committing extortion. They're violating the Hobbs Act. And we could arrest and jail every damn one of them. So let's go take a look at Hendricks versus Maryland. Right? And this is the non-exercise of power by Congress under Head Note 1. Right? Because this is what the lawyers and everybody's always pointing to for this case under 235 U.S. 610 for the site. Right? And they say, oh, well, Hendricks versus Maryland gave the government the right to regulate the highways or regulate people's cars. Well, it did, but it only gave them the right to regulate certain cars, those that are moving in interstate commerce. All right. Now, I've got this case here from LexisNexis. I also have a copy of it from Westlaw and a copy of it from Casetext. All three, the head note is the same. It says that in the absence of federal legislation, the state can prescribe uniform regulations reasonably necessary to the operation on their highways of automobiles moving in interstate commerce. And people say, oh, now wait a minute. Hendricks, he wasn't moving in interstate commerce. Well, actually he was. You see, Mr. Hendricks in this case was a representative for his state. He was one of the reps coming home from D.C. to visit his family. And anytime that you become a part of the government in that factor, in that essence of being a representative, you lose your right to travel in your car without registering it and all that, because they have decided that whenever you're a representative in such a form, that you are always in commerce. They always consider you to be in commerce no matter what you're doing, and therefore you labor under every restriction possible, meaning you have to have driver's license, you have to um, register your car. You have to do all these things. And this is why they said what they said. And it becomes very clear in Head Note 5 when you look at it, and it says a resident of the District of Columbia failing to show compliance with the laws of the district as to registering automobiles and licensing operators, or that he has applied for local identifying tags required by laws to a limited use, right, of the highways by non-residents, cannot complain that residents of the district are not among those to whom this privilege is granted. Now there's 72 cases that shows you that a resident of the District of Columbia. Well, the only people who are residents of the District of Columbia are people who are working for the government. Right? And again, shows you that the Maryland law applies to carriers. Right? So if you work for the government, you're treated the same as a carrier. And this is a lot of people don't understand this case, because they don't understand that because Mr. Hendricks worked for the government, he did not have the right to travel. He was considered to be in commerce. Right? And that is why the Hendricks versus Maryland case said they could regulate him, because he was considered to be in interstate commerce. He was a representative traveling home. And you see here in the constitutional law, in the absence of an act covering the subject, a state may impose upon vehicles using its highways in interstate commerce non-discriminatory regulations for purposes of ensuring the public safety and convenience, and for the protection and conservation of the use of such highways. Generally speaking, highway regulation has been left to the states and localities, and traffic laws they enact must be applied both to intrastate and interstate traffic. Now this is important, because what is traffic? Well, they've said that traffic is commerce. If you look up traffic under any of the law books, it will define traffic as commerce. Right? So when you're talking about intrastate or interstate traffic, intrastate is anybody using the roads as a place of business for commerce inside the state. Interstate is your people who are leaving one state and traveling to another state to deliver the goods that they're transporting in their business. Right? Or the people. You know, if it's Greyhound bus, then they're transporting their passengers. And there's some other things that I'll be showing you that you'll have to pay attention to, such as when the police say, well, you have passengers. You need to immediately say, no, I do not have a passenger, I have a guest. Because passengers is somebody who pays a fare for your rate. A guest is somebody who's just traveling along with you. And again, don't be mad at the police, right? The lawyers are the ones who have lied to the police and told them, oh no, this is all a bunch of sovereign citizen crap. Just like the lawyers will try to tell you that AmJur, or American jurisprudence, is nothing more than an encyclopedia. And that's not true. It's an encyclopedia of constitutional law, right? And one of the things that I will show you is this here. I'm going to go up, open this up, let it load, get the PDF, and we'll blow this up so you can see it. This is, again, from Westlaw, the American Jurisprudence in Corpus Juris Secundum on the Law Report. Right? Now, this tells you that the American Jurisprudence, or AmJur, family of products provides you with fast, authoritative answers to any aspect of civil, criminal, substantive, and procedural law. Now, let's look at that. Authoritative. What does that mean? Well, guys, that means it's this, that when somebody lays up constitutional law covering that subject, that's the end-all, be-all. It has the final say. Right? Because it's authoritative. Well, then we come over here and we look at Corpus Juris Secundum, right? And what does it say? That Corpus Juris Secundum is a comprehensive legal encyclopedia containing over 400 topics that are cited and quoted as authority in courtrooms across the United States. In each article, the broad principles of the law are explained and put into context so you know how they are to be applied by lawyers and the courts. Whoa, now wait a minute. So, if you're looking at American jurisprudence or Corpus Juris Secundum, and you're reading something like this here, for 7 AmJur 2D automobiles, subsection, federal regulation, and it tells you that the power of the federal government to regulate interstate commerce gives it control over motor vehicles engaged in business between one state and another state in the same degree as such control exists as to any other class of vehicles engaged in the same occupation. And then it tells you that examples of such federal regulation include the Motor Vehicle Safety Act, which purports to reduce traffic accidents and deaths and injuries from traffic accidents. And it says that the Act states that it is necessary to prescribe motor vehicle safety standards for motor vehicles and motor vehicle equipment in interstate commerce. Well, right there, the first 5 provisions of 7 AmJur, subsection 17, tells you the limit of the federal government's power as to who they can require to have license, insurance, registration, all that. Right? And like I said, this right here shows you that these legal encyclopedias, they tell you how the lawyers and the courts are supposed to be applying the law. Now, how did you get any better than that? You know, that's a beautiful thing to have right there. Let's look at this Waters versus Michigan. We'll show you that there's several cases here that support what I'm telling you. These are cases that have come out from Charleston, South Carolina, Florida, Michigan, all over the place. Right? These are all U.S. Supreme Court cases, all holding to the same thing that says a state may, by appropriate legislation, require payment of an occupation tax from one engaged in both intrastate and interstate commerce. Right? You know, and here's one from the Superior Court of Pennsylvania. Here's the U.S. Supreme Court. Tells you it's been cited 35 times. Davis v. Department of Labor. There is tons and tons and tons of cases here that shows that this is a fact. And it doesn't matter how much they want to pretend it ain't that way. And to show you, you know, this is a case that I helped with Ed Strzok, and he got his dismissal. Matter of fact, let's just show you this. He turned in the paperwork I gave him, and he now mind you guys, you know, this is just this year or last year, I think. Yes, February of 2022. All right, so this case is only a year old for Indiana, right? But Ed turned in all the paperwork I gave him with the 52 exhibits of constitutional law and court cases. And 3 days after he filed everything into the court, demanding that the prosecution be required to prove jurisdiction and prove that it applied to his car, that he was not operating for compensation or for hire, the prosecutor come running within 3 days and motioned the court to dismiss the case in the interest of justice. Now, when they're talking about the aforementioned charge to be dismissed, the charge was that they were charging Ed for driving without a license. Right? Now we're talking about the chief, the head prosecutor here, come running. Wanting it dismissed. And the judge signed it in the Superior Court. Because they could not prove that it applied to Ed's car. Right? Now, here's the main reason that I brought this up is I wanted you to see this case, because most people do not understand. This case comes from Westlaw. And this is Washington State Department of Licensing versus Cougar Den Inc. Now, this case was a case between the Yakima Indian tribe and the Department of Licensing in Washington State. And I'll give you a brief overview of that case right here. Now, everything that you see right here, I got out of the Cougar Den Inc. case itself. This is not my words. This is their words. Right? And this was the United States Supreme Court. The case was argued October 30th of 2018. It was decided in March 19th of 2019. So this is a really new case. Right? Now, the holding of that case, Supreme Court Justice Breyer, joined by Justice Sotomayor and Justice Kagan and Justice Gorsuch and Justice Ginsburg, concurring in the judgment, held that Washington's fuel tax burdened the treaty right of the Yakama Nation to travel upon all public highways in common with citizens of the United States. Right? And they said the Washington tax, as applied to its activities, is preempted by the 1855 treaty. Now, this is the only thing the lawyers want to focus on. They said, "Oh, well, they violated the Indian Treaty, right, and all that." They don't want to tell you that there were some things going on. We need to hold on just a minute, guys, because I need to pause this real quick. I've got to... Okay, guys, I'm back. Sorry about that. I had some very expensive knives show up that were ordered for some cooking things that that my family does for veterans and stuff. Okay, but anyway, they held that it violated that, and that's what the lawyers want to focus on, is that, oh, they violated the treaty. However, what they're not acknowledging is that the Yakama tribe, or Yakama Nation, that they recognized, and the court recognized, the reservation of certain rights in the treaty, right? And those rights included the right in common with citizens of the United States to travel upon all public highways. It included the right of taking fish at all usual and accustomed places in common with citizens of the territory, and other rights such as the right to hunt, to gather roots and berries, and to pasture cattle on open and unclaimed land, citing Article 3 of the Constitution, right? And it says, to summarize, the holding rested upon three propositions. First, a state law that burdened a treaty-protected right is preempted by the treaty. The plurality simply assumes that the right to travel with goods is an additional substantive right when it reasons that the fuel tax is preempted because it taxes an integral feature of travel with goods. The concurrence makes the same assumption when it compares the fuel tax to a tax on possession of fish. It's just another way of describing the act of fishing. Instead, they suggested that the Yakama tribe understood the treaty right to travel provision to provide them with the right to travel on all public highways without being subject to any licensing or permitting fees related to the exercise of that right. while engaged in the transportation of tribal goods. Now, what you got to remember here, folks, is that Yakima Treaty, it's like the American Constitution, right? And you need to remember the Yakima tribe shares the right in common with citizens of the United States to travel upon all public highways without being subject to any licensing and permitting fees related to the exercise of that right. And that's where we find this stated in a roundabout way at 16 Amjur 2D Constitutional Law subsection 624, which I was reading to you earlier about the constitutional guarantee for liberty, right? And showed you how it tied into public vehicles, which were vehicles that were operated for hire. And yes, you'll be able to download this legal notice, but I encourage you, when you send a legal notice like this to your local law enforcement, to the sheriff and the chief of police, the state police, don't just send them the notice citing the law. You go through and you get the law that's cited and you send it with it. Right? So that the sheriff or the chief of police or whoever the individual is that's in charge of the state police that you're sending it to, they can read it for themselves. Right? Now at that point it's up to some freaking lawyer to convince him that the power of the state is for licensing goes beyond motor carriers. And the constitutional law says they're limited to just that. So what are they going to do? Okay? And you remember I told you that earlier that when it includes one thing, when it enumerates it, that enumeration weakens the force of the general law as to things that are not expressed, right? And it says, in this regard, the canon of construction, expressio unus est exclusio alteris, and I'm not sure I'm pronouncing that right, my Latin is shit, but that's a whole nother ordeal. But what it means is that it holds to express or include one thing implies the exclusion of another or of the alternative, right? So something that is mentioned, one thing in a statute, impliedly excludes another that's not mentioned. Now, this isn't always a 100% of the time thing, of course. There are certain statutes that the language, as you read it, very clearly includes everything, right? But that's just the way that goes. Some people argued that, oh, well, that don't pertain to motorcycles. Well, that's not true. Because right here you have constitutional law that says that motorcycles are lawful vehicles and their rights on the highway are the same as those of automobiles. So when they're telling you got to get a motorcycle license, they're saying that you're providing transportation with that motorcycle, or you're using it in a business delivering stuff back and forth to various places, whether you're having a passenger on the back that you're taking them to a place of business or whatever that's paying you to take them there. That's what they're claiming when they say you got to get a motorcycle license and register your motorcycle. Right? And this is the older constitutional law, which the certificate of insurance, again, was only required for motor carriers. So if you're not a motor carrier, the BMV is violating the law, because they're saying, oh, you gotta have insurance in order to plate your car. Well, that's not true. Right? And there is a little black plate that you can get from the BMV that just shows, it's a black and white plate that all it does is show ownership. Right? It just shows you own it. But that's another deal. If you want to do that, you don't have to register it. And when you start digging deep into your code for your state, like you'll find what I found here in the Indiana code under 918.222 in 2016. Now this is 2016, guys. Again, not that long ago. Right? It said, or read, a person that owns a motor vehicle, except a person that owns a truck or a motor vehicle used in transporting passengers or property for hire, and they have obtained a certificate of registration under this title, is not required to pay another license fee, obtain any other license or permit to use or operate the motor vehicle on the highways, or display upon the motor vehicle any other number other than the number issued by the Bureau. So you see that? If you're not for hire, they're saying you don't have to have a driver's license. Now that's state law. So the state law is all in line with the constitutional law, isn't it? And you know, some people say, "Oh, well, it don't matter. That's expired now." Well, it doesn't matter, because it's evidence to the legislative intent. And the legislative intent and the constitutional law is what has to win out. Right? Now, the other reason it's like this is because the legislature cannot, however, prevent citizens from using the public highways in the ordinary manner. Are you catching that? Well, what's the ordinary manner? Isn't that us just traveling to and from our jobs and to and from the grocery store? And they're saying the legislature cannot prevent you from using them in the ordinary manner to travel. In other words, they can't tell you that your car has to be licensed and that you have to be licensed for you to go to the grocery store, or go see the doctor, or go to work. Right? And some would say, well, why is that? Well, right here. This is why. The public are entitled to a free passage along the highway. Well, if you got to pay license fees and all that, is it free? No. So if you're entitled to free passage, they can't charge you. Right? And it says the existence of a public highway creates a public easement of travel which permits the general traveling public to use the highway at will Well, if it's at will, that means as soon as you're ready to use it. I don't mean, oh, well, first I got to go get my car registered, then I got to go get my license, then I got to get insurance, then I got to do this, then I got. No. At will is, hey, I've got a truck sitting out there that runs. I need to run to the grocery store. Because traveling by car, well, isn't that part of the ordinary manner? Huh? Some people might want to disagree with that. But it's ordinary for folks to travel by car, isn't it? Now, look at this. The public's right to the use of the streets for travel is absolute and paramount, and greater than that of an individual to occupy it for other purposes. Streets and highways are primarily for the benefit of the traveling public, and only incidentally for the benefit of property owners along them. Right? Now remember, those are all constitutional provisions. But, I mean, it's pretty clear to see at this point that driving is a regulated occupation for hire. Right? And that the operator or driver's license is an occupational license. But just to prove this point, let's go look at 16C, Corpus Juris Secundum, CJS, Constitutional Law, subsection 1531, driver's licenses. Part 6, privileges and immunities, equal protection. 17, subjects and applications of equal protection guarantee. K, taxation, licenses and license tax. 2, licenses and license or occupational taxes. Whoa, ain't that a huge... The license is an occupational tax that you pay for motor vehicles and operators? Well, an operator's license, that's exactly what they want you to get. Right? They're telling you got to get an operator's license. But that operator's license is an occupational license. I mean, this stuff is huge, people. It's really huge. And if you start doing your paperwork correctly and entering this stuff as exhibits, and getting everything done the way you should, you know, like I said, you'll have access to what I've got written here, which means you can take this and make your own paper and say, hey, look, you know, I have a fundamental right here to use the streets that's supposed to be guaranteed to me to travel about by the ordinary manner. Do people not ordinarily travel by car? Well, they do. Well, then I'm allowed to do that at will. It says so right here. And you can't require me to go get licensed and leave this unlicensed group classification to become a licensed group. part of the licensed group, right? This is, one of the things about constitutional law. Remember, each one of those deals with a number behind it that I was showing you. Underneath these is a constitutional provision, right? So now we're down here to this, and it says a constitutional provision must never be construed in such a manner as to make it possible for the will of the people to be frustrated or denied. Right? So when these guys are all lying about these laws and pulling all this crap, we've got them dead to rights. And we have numerous cases. We have so much constitutional law, it's not even funny. Alright? Because something cannot be a fundamental right, but yet only be a right so long as you first go get licensed by the government. Okay? If you have to first get licensed, it's not a right. That's a privilege. Privileges can be taken away. Right? And you need to understand that constitutional law is the department of law that deals and treats constitutions and the validity of enactments that's been done as tested by the criterion and conformity to fundamental law, because that's what a constitution is. It's fundamental law. Right? Now, it tells you right here when you're looking at the words constitutional law, right? It says in constitutional law. The word constitution implies the written instrument agreed upon by the people as the absolute rule of action and decision for all departments and officers of government in respect to all points covered by it, which must control until it is changed by the authority which established it. That's 16 CJS Constitutional Law subsection 4. Right? Now what you have to remember is that American jurisprudence and CJS are both constitutional law. And the constitutional law, as I've said, is the end-all be-all. When you're dealing with a subject in law, such as the right to travel, and you lay it down and it limits the government to only having the authority to license motor carriers, that's it. They don't get any more authority than that. That's the end of their authority, period. Not because I say so or because you say so, but because the law says so. And these lawyers are lying through their teeth to the police. Like I said, don't be mad at the police. If anything, go talk to them. Show them what you have. Show them what you've discovered, and show them that the lawyers are lying to them and committing felonies. And then ask them if they're going to stand beside you and your friends to go around and do citizens arrest, which I'll have another video up later covering that. and the proper way to go about citizens arrest. Because believe me, you want to go to your state, your county, and your city police first and inform them of what you're doing and ask them to have an officer accompany you to perform the arrests of whoever you're going to perform it of, so that you can turn that person over to that officer's custody so he can take them to booking, to the jail. And I will get into the law that shows that the officer, if you make the arrest, he has no liability. His only job at that point is to take possession of the person who you're turning over to be booked and take them to the jail for booking. That individual cannot hold the officer liable. It's not up to the officer to decide whether or not that individual has broken the law. Okay? Now, the other thing is the vitality of constitutional principles, guys. You see right here, it says it cannot be allowed to yield simply because somebody disagrees with it. Right? And it says that an effort to accommodate community sentiment or the wishes of the majority of voters, although usually valid and desirable, cannot justify the abandonment of that constitutional concept. Right? So even if all the public thinks that you should be licensed, it don't matter. The constitutional law makes it very clear who they can license and who they can't. They cannot abandon that to expand the law for their own benefit. Right? And that's in subsection 7 of 16 CJS. And then you see here that statutory law, in order to be valid, must conform to applicable constitutions, both federal and state. And I'll get into an example on this in another video later on child support. How child support violates every single state constitution there is. But because both the judge and the lawyers of every state, mind you, every single lawyer in your state has been required to contract with the Child Support Collection Agency. Now, what you don't know is this means no lawyer can represent you and contravene what the Child Support Agency wants, because he's already under contract with them. Which means he was barred from representing you when they brought a case against you. And I don't care what lawyer it is in the state, they're all under contract. The judge is under contract. And mind you, in the contract, he only gets paid if you get found guilty. Same way with the prosecution. He's under contract. And he only gets paid by the Child Support Agency if you are found guilty. Right, majorly unconstitutional. Do you think these judges are going to piss away the money and find you not guilty? When he has a financial incentive that he's going to get for finding you guilty, right? And that varies from each state. About 10 years ago when I was looking at it, it was $35 per case. For every case they seen, they got $35 whenever they found them guilty. Well, people say, well, it's just $35. That ain't much money. Well, no. But what if they handle 50 child support cases in one day at $35 a pop? Right? And just to, let's be accurate, and we'll just bring up this little calculator here, right? And we'll say, hey, he got $35 times 50 cases. That means for that day, he netted an extra $1,750. And that's if he only saw 50 cases for child support. Many courthouses, they're running them through wholesale, and they're seeing 30, 40, 50, 60 or 70 cases in a day. So stop and think about if you can increase your income by $1,000 a day simply by finding somebody guilty. And not just the judge, the prosecutor. Right? Because he's getting paid too. So now you got two individuals who have been majorly incentivized to find you guilty. Now, the state wants to tell you that a driver is anybody behind the wheel. Here's the problem with that. The federal government, and this is their area where they get to regulate, has already given the definitions. Right? So, driver means anybody who's operating a commercial motor vehicle. In other words, are you for compensation or for hire? Right? Interstate commerce. Right? Interstate commerce means any trade, traffic, or transportation in any state which is not described in the term interstate commerce. Here's what they've defined a motor vehicle as. Here's a motor carrier. Motor carrier means a for-hire motor carrier. Right? And then when you get to 390.5T under 49 CFR, the Code of Federal Regulations, they've defined a for-hire motor carrier to mean a person engaged in the transportations of goods or passengers for compensation. So it's pretty clear, right, what they were laying out. And like I said, all of these links up here that will take you to these court cases and all that, it'll all be up here. right? And you'll have access to all these 52 exhibits that Ed used, all the cases, right? The Hendricks versus State, all this stuff, all the constitutional law, so that you'll be able to read it and see it for yourself. Right, but this is very clear that the states, they don't get to regulate every single car on the road. But that also means you don't, doesn't mean you get to ignore stop signs or speed limits, right? Because you, as an individual, have a care of duty to travel about safely and not endanger your fellow Americans. Be they a man or a woman, you have a duty not to go bebopping around doing dumb stuff. Right? And see, right here's another deal for 51M juror for licenses and permits, which talks about the taxing power of the state. Right? Again, it tells you that license charges may be imposed for regulation or for revenue or for both. A state may not impose a charge for the enjoyment of a right granted by the United States Constitution. Right? But they're telling you right here that private corporations, they can be made to pay for the license for compensation for services in carrying out the laws, or be paid for compensation of persons suffering damage from the thing licensed. But as you've seen in here, they can't make you get this stuff. They can't make you do stuff. Contrary to what a lot of people think, they cannot do it. And when I was showing you the federal definitions, this is where preemption by federal legislation comes in. Because this is an exclusive field for the federal government. Once they define a term, the state has to use that same definition. They don't get to go and make their own. And that's all covered right here under preemption, which when you read that, you'll understand. Right? It tells you that, hey, if the federal government has legislated how a motorcycle helmet's got to be, the state doesn't get to set a different standard. The only standard required is the one that the federal government set. And see right here, you see where it talks about preemption of state and local stuff again. There's so much stuff here that backs up what I'm telling you. But if I was to keep going on and on and on and on about it, the video would be way too long. And we would run out of time. When I talked about the Hobbs Act, right? That is right here. And it covers extortion. Because when they're making you pay for this stuff that doesn't actually apply to you or your car, they are violating a federal statute known as the Hobbs Act. And it provides that whoever in any way or degree obstructs, delays, or affects commerce, or the movement of any article or commodity in commerce by robbery or extortion, or attempts or conspires so to do, or commits or threatens physical violence to any person or property in furtherance of a plan or a purpose to do anything in violation of this section, shall be fined under this title or imprisoned not more than 20 years or both. Right? And the Hobbs Act defines extortion to mean the obtaining of property from another with his or her consent induced under, among other things, color of official right. The Hobbs Act is applicable to federal officials and prescribes extortion involving the obtaining of property from another under color of official right, or the wrongful taking by a public officer of money or property not due him or her or their office. In general, the Hobbs Act applies to any payment to a public official to which the official is not entitled, and which payment the government official knows is made in return for his or her official acts. And if an individual violates the color of official right prong of the Hobbs Act when he or she encourages or accepts a payment knowing that it was prompted by hope that the official will be influenced in the exercise of his or her powers. So when they're threatening you, oh, you got to get a license or we're going to impound your car, they're threatening to take your property if you don't do what they say. Right? And by the way, this does apply to state officials as well. You'll find other sections of the law that tells you it applies to state officials as well. It ain't just for federal. Right? But it says that the Hobbs Act extortion, that is obtaining property from another with his or her consent under official right, includes the rough equivalent of taking a bribe. To prove Hobbs Act's extortion under color of official right, the government need only show that a public official has obtained a payment to which the official was not entitled, knowing that the payment was made in return for official acts. Well, when you go get a license plate, ain't that an official act? You go get a license, ain't that an official act? Right? It says a court will also uphold a conviction for a Hobbs Act extortion under color of official right where the evidence indicates that the payor made a payment to the defendant because the payor held a reasonable belief that the defendant would perform official acts in return, and that the defendant knew that the payment made the payment because of that belief. Extortion under color of official right requires the government to prove the bribe giver was motivated to make payments as a result of the defendant's control or influence over public officials. And the defendant was aware of this motivation. Well, we're all aware of why they're forcing us to do these things. And by the way, I've got a thing on property tax I'm going to be doing that shows that when you own your house outright and you don't have a loan on it or anything like that, you do not owe the property tax. They cannot collect it from you. It's illegal. The constitutional law says, I've got constitutional law that says that when you own your property in that manner, they cannot take it. They cannot touch it. But see, here's the beauty about the Hobbs Act. Extortion under the Hobbs Act does not require a direct benefit to the extortionist. Right? The gravamen of the offense is lost to the victim. The official need not actually have the powers he or she threatens to use. And the victim need not actually know the official's position. It is enough that the victim reasonably believes the official can do what he or she threatens. Well, every one of these judges are always threatening they're going to throw you in jail if you don't go get a license like they tell you. Every single one of them is violating the Hobbs Act. Right? And that's what I'm saying. When you learn how to do citizen's arrest, think what happens if you go into a court and a judge is trying to do that, and you have 20 educated people around you, and everybody says, okay, bailiff, get the sheriff up here, please. Because here's the stuff that the judge is violating. The judge has been given the actual law. So is the prosecution. They're both in violation of the Hobbs Act, and we are all here to make citizens arrest. If the judge wants to violate the law, we're going to show him that we're not going to put up with it. And the judge, he's getting paid to do what he's doing. So he is acting for his own benefit as well as the government's. Same with prosecution. Right? So this little section right here, a lot of people think, oh well, they took my land for the government. No, they may have taken the land for the government, but they took their land because they were being paid. And they wanted to stay in good graces with the boss. So, as far as that goes, right, there's extortion and all that. So this is common law extortion, right? And it was a property offense committed by a public official who took any money or thing of value that was not due to him or her under the pretense that he or she was entitled to such property by virtue of his or her office. Extortion by a public officer has been defined as the corrupt demanding and receiving by an officer by color of office of money or other thing of value that is not due at all, or more than is due, or believed it is due, or before it's due. Sorry. See, does the judge not demand that you pay a traffic ticket for not having a license to the court? To him? Same thing with the prosecution. Are they not both making money off of it? Through their wages and through percentages of the ticket that goes back to the court? Let's see, here's your stuff on color of office. There is a ton of stuff, right? Extortion or blackmail, who may commit it? This is the one I was telling you about that tells you that a state official can do it, right? There's loads and loads and loads of stuff in here for you to learn and read. But at that point, guys, I'm going to close this out. Like I said, all the links to all this stuff I'm showing you will be down below the video. So you'll be able to go and download all this and see it for yourself. And download all the case law and see it for yourself. You know, each thing will be there. Just leave your comments and let me know what you think after you've looked stuff over. If you disagree with me, that's fine. That's the beautiful thing about America. We can disagree. That's one of the beautiful things about here in America. We don't have to hate each other and fight and carry on just because we disagree. So, with that, enjoy the information and the time that you have. Have a good one, guys.